It's quite surprising how a lawyer who initially came to court as a witness to defend Tinubu ended up affirming and justifying everything that the Labour Party stated in their petition. Unfortunately, many people didn't pay close attention to the courtroom proceedings. This individual entered the courtroom with an air of confidence, flaunting their extensive CV and boasting about their experience. However, things took a different turn when the Labour Party's lead counsel began questioning them, systematically dismantling their arguments one by one. Initially, the U.S. government froze a total sum of $460,000 in Tinubu account and confiscate his properties based on narcotic trafficking and other criminal offense in a specific section of the U.S. Constitution, even naming the particular section. Upon investigation, it was found that the judgment on the forfeiture made by Tinubu in the U.S. was indeed based on 18 U.S.C. 982, which pertains to criminal forfeiture related to illegal activities like drug trafficking or money laundering. The gravity of Tinubu's case is evident to further explain that if he decided to stay in the United States in 1993, he would convicted and served his jail term. However, he was in Nigeria at the said time, so all it took was a phone call. Plus, Nigeria never had a bilateral agreement with the United States government regarding the exchange of prisoners or individuals who committed crimes in each other's countries, like the case of Buruji Kashamu. If such agreement had been in place, the U.S. government could have made an extradition request without hesitation. Now, let's bring the discussion back to Nigeria for better comprehension. Imagine if the National Drug Law Enforcement Agency, NDLEA, were tracking certain individuals, and upon catching them, they discovered that someone, regardless of their high standing, had been involved in illegal drug trades, with funds linked to narcotics in their bank accounts. The NDLEA would undoubtedly pursue that person, freezing their account and initiating legal action. In such a situation, it would be considered a criminal offense, not otherwise. That's precisely what happened to Tinubu in the United States. Some might wonder why Tinubu still have access to traveling to the United States if he had committed such grievous offense. Well, there are two reasons why to prove he commit the crime, and he cannot be arrested even if there's proof he obtained visa from the United States indicating that he traveled there and back. Firstly, there is a policy in the United States that seems to refrain from going after politically exposed persons abroad. For example, Atiku Abubakar, a former vice president, was indicted by a U.S. Senate committee for money laundering when he was in office. However, they did not pursue him or make an extradition request due to his politically exposed status. Their priority lies solely in protecting their own country's interests, regardless of who governs Nigeria. The second reason is that it doesn't make economic or legal sense for the U.S. Department of Justice to go after someone they have already recovered money from. It would require spending additional funds on prosecuting the person in court. Therefore, the state has nothing to gain, but rather stands to lose by pursuing a case against someone from whom they have already recovered illicit funds. This is why Tinubu's legal team emphasizes this point. It's important to note that the judges presiding over the case are experienced professionals who conduct thorough research and possess extensive knowledge in their field. Despite having all the evidence and judgments before them, they still conduct their own investigations to ensure accuracy. After evaluating all the evidence and conducting their own research, they will pass their judgment. Tinubu should genuinely be concerned this time. There's no way for him to escape this. The implications for him are clear. Disqualification is imminent. Instead of worrying about the outcome of this petition, people should focus on the larger picture. Regardless of how it unfolds, we are all in this together. If, after examining all the evidence, it is determined that Tinubu is innocent, then our collective trust in the electoral process will be severely undermined. Citizens may lose faith in the system, leading to decreased voter turnout because of electoral manipulation, and a lack of accountability from those in power, ultimately resulting in a failed state. We must not underestimate the impact of these proceedings on Nigeria as a whole. Another common question that arises is what will happen to those who presented evidence showing that Tinubu's name was not on the register in Anambra before the election. However, instead of focusing on that, We should question why the so-called winner of the election is seeking to disqualify the loser. Isn't that peculiar? Furthermore, the section they are relying on in the Electoral Act does not state that a political party or any party must stop accepting new members after submitting their register to INEC 30 days before the primaries. The party retains the right to continue accepting new members, and they cannot update their register daily and deliver it to INEC before the primaries. Additionally, there is a unanimous appellate court judgment that dismissed the matter before the election and even awarded N200,000 to P2B and others. Let us keep these factors in mind and stay vigilant. The outcome of this petition will have far-reaching implications for our democracy. We cannot escape the consequences. We must collectively address them. Running away is not at all. We must stand together and fight for the future we desire, where every vote counts and our nation thrives.